Hi, this is Jeff Grell, and today we're going to cover the basic elements of a RICO claim, both substantive liability under Section 1962C and civil standing under 1964C of Title 18 of the U.S. Code. We'll also try to fit in some time for discussion of statute of limitations, because that can be a complicated issue under RICO as well. When you consider the nature of a RICO claim, RICO is intended to reach defendants who never get their hands bloody. There were a lot of laws on the books to address people who actually engage in criminal activity, but the unique thing about RICO was to impose liability on people who didn't necessarily commit crimes themselves. Under RICO, you're liable for operating and managing another group of people, or another legal entity, or another person, another individual, pursuant to a pattern of racketeering activity. When you look at 18 U.S.C. 1962, you see that there are four subdivisions. In layman's terms, to simplify, 1962A is basically a money laundering provision. 1962B is a loan sharking provision. 1962C is a catch-all that essentially applies to much more general types of activity. And 1962D is a conspiracy subdivision. For our purposes today, we're going to discuss the elements of a 1962C claim, because 1962C is where the vast majority of civil RICO claims are brought. The reason for that essentially relates to RICO's proximate cause requirements, which we will talk about later in the video. So what are the elements of a 1962C violation? The elements of a 1962C violation are, first and foremost, you need to identify a defendant person. Now, normally you don't consider the defendant to be an element of any kind of substantive liability, but under RICO it's very important to identify the person who is going to be liable, because you need to distinguish that person from the enterprise. And the enterprise is the second element of a RICO claim. Third element of the RICO claim is that the defendant person has to operate and manage the enterprise. And finally, the defendant must operate and manage the enterprise through a pattern of racketeering activity. First of all, when you begin with the defendant person, it's important to note that only defendants are liable under RICO. Very often I get calls from people who say, I want to bring a RICO claim against A, B, and C Corporation as a racketeering enterprise. Well, you're kind of mixing apples and oranges there. If you want to sue ABC Corporation, then they need to be named as the defendant person. And they cannot be the enterprise, because the defendant must always be distinct from the enterprise. Like I said, it's important to identify who your defendant is, because only defendants are liable, enterprises are not liable. Enterprise is simply that instrument that is manipulated by the defendant to engage in criminal activity. The other thing that you need to consider when you're looking at a defendant person is who you're going to sue. Obviously, for civil purposes in any civil claim, you want to sue a person with deep pockets. What good does it do to get a judgment against an entity or individual that has no money? And so once you identify that person that can pay a judgment, then you need to figure out an enterprise that's going to be distinct from that person. Governmental entities generally are not good defendants. There's a long history of jurisprudence that states that essentially governmental entities cannot form the necessary mens rea to commit criminal activity, because governmental entities are essentially the agent of the body politic. They're the representatives of the electorate. And so as a governmental entity, it's necessarily impossible to establish that the electorate as a whole possessed the necessary criminal intent to engage in the acts of racketeering activity upon which a RICO claim must be predicated. So governmental entities are not good defendants. Governmental entities can be enterprises. For example, if you wanted to sue a corrupt judge, or you wanted to sue a corrupt bureaucrat, or you wanted to sue a corrupt mayor that's getting kickbacks or is being bribed, you could allege that the governmental entity is an enterprise, but you would want to allege that the defendant person was the individual government agent who is necessarily operating outside the scope of their employment as a government agent and therefore not entitled to any immunities. Finally, insurance companies are bad defendants. Insurance companies have the benefit of a statute known as the McCarran-Ferguson Act. The McCarran-Ferguson Act essentially says Congress won't regulate the business of insurance unless Congress specifically says it's regulating the business of insurance. Rico does not include any language that specifically applies Rico to insurance companies. So if you're going to sue an insurance company, you have to be aware that anything that essentially involves the business of insurance is going to present a very high hurdle to get around. Insurance companies have this additional layer of protection. Why they have this additional layer of protection you can debate, but essentially the federal government has passed the McCarran-Ferguson Act, and in doing so states that regulation of insurance companies is essentially left up to the states. Now, it doesn't mean that it's impossible to sue an insurance company under RICO. It's a different level of analysis, and that analysis would be found under cases interpreting the McCarran-Ferguson Act. So, element number one, you need a defendant person. Element number two, you need an enterprise. Section 1961, subdivision 4 of Title 18 defines enterprise as any individual, partnership, corporation, association, or other legal entity in any union or group of individuals associated in fact, although not a legal entity. So essentially, an enterprise can be a single person, an individual. It can be any sort of legal entity, such as a partnership, corporation, association, or other legal entity. I have alleged that trusts can be enterprises. I've alleged that nonprofit groups can be enterprises. I've alleged that governmental corporations can be enterprises. Essentially, any legal entity that is created under some kind of statutory authorization. And then the final type of enterprise, and probably the most common type of enterprise, is the association in fact enterprise, which is a fancy way to say a group of people. Now, the reason why association in fact enterprises are the most common enterprise is because RICO was adopted to combat the mafia. And the mafia is essentially a group of people that's engaged in criminal activity and is operated and managed by Godfather. When a lawyer who isn't accustomed to suing out RICO claims thinks about RICO, they generally think about a group of people like the mafia. They don't think about other types of enterprises like individuals, corporations, legal entities, that sort of thing. So pretty much I would say the vast majority of RICO claims that I see allege an association in fact enterprise. Why people do that, I don't know. I generally try to avoid alleging association in fact enterprises if possible, and that's because the requirements of alleging an association in fact enterprise are much more rigid than they are for the other types of enterprises like individuals or legal entities. And so don't overlook the other options, individuals and legal entities. As I said before, the defendant person must be distinct from the enterprise. What does that mean? Well, quite simply, it means that if you're going to sue John Doe as the defendant person under RICO, you can't name John Doe as the enterprise as well. Similarly, if you're going to sue Corporation ABC, you can't name Corporation ABC as the enterprise. Where it gets more difficult to apply is obviously in more realistic situations. For example, if you're going to name John Doe as the defendant, you can name Roger Smith as the enterprise. And that's the thing that throws a lot of people off. A lot of people think, well, RICO only applies to big groups of people. The defendant has to operate and manage a big group of people. No. Actually, larger enterprises only create more problems. When I'm looking at trying to allege an enterprise, I generally try to allege the smallest enterprise possible. Even when it comes to association in fact enterprises, an enterprise of 2 people or 2 legal entities is just as good as an enterprise of 200. So adding complication to your claim isn't always a good thing, and in fact it's seldom a good thing. So don't overlook the fact that you can name an individual as an enterprise. Just make sure that that individual is distinct from the defendant person. Similarly, you could allege that Corporation ABC is the defendant and Corporation XYZ is the enterprise. Now, where that gets a little bit more tricky is when you're talking about a parent company of a corporation. Some courts will say that you can't name subsidiaries or affiliated corporations as enterprises that are being operated and managed by the defendant parent corporation because they're not sufficiently distinct. One court that has held that a parent company cannot operate and manage a subsidiary or affiliated corporation within its corporate tree is the Seventh Circuit decision of Fitzgerald versus Chrysler Corporation. That's found at 116 F. 3rd 225, 7th Circuit, 1997. But the interesting thing about that rule is that the corollary doesn't seem to apply when you're talking about a natural person who has an LLC or a subchapter S corporation, and essentially that legal entity is the alter ego of the natural person. When you go to the Supreme Court case of Cedric Kushner Promotions Limited versus Don King, that's at 533 U.S. 158, 2001. The Supreme Court said that, yes, an individual is sufficiently distinct from a corporate entity that is basically the alter ego of that individual. And so it is perfectly fine for a plaintiff to allege that Don King, as a defendant person, is distinct from Don King, LLC. That shouldn't come as too much of a surprise because obviously legal entities are always distinct from the people who incorporate them. But Rico is one way to get around the need to pierce the corporate veil and other such things. If you want to simply allege that the CEO of a corporation is operating and managing the corporation through a pattern of racketeering activity, that's sort of the fundamental nature of a Rico claim, and thus it translates to individuals who form a corporate alter ego and they operate and manage that corporate alter ego through a pattern of racketeering activity. So we've talked about individuals being distinct from other individuals. We've talked about corporations being distinct from corporate entities. We've talked about individuals being distinct from their corporate alter egos. But we haven't talked about association in fact enterprises. And so when you look at association in fact enterprises, there's a couple of rules that are important to remember. First of all, an individual is always distinct from a group to which the individual belongs. So what does that mean? That means that you can allege 2 or 3 defendant persons, and you can turn around and allege that those 2 or 3 defendant persons are also an association in fact enterprise that's operated and managed by the defendants. And there's a number of cases that hold that. Pretty much every circuit that has considered the issue, and most of them have opinions that will support that rule. So yes, you can name defendants A, B, and C operating and managing an association in fact enterprise consisting of A, B, and C without violating the person enterprise distinction. The other thing that's important to remember when you get to association in fact enterprises is that it's okay to allege, for example, a CEO or a chairman of the board operating and managing a corporate entity as the enterprise, but you can't do the converse. For example, let's assume that the corporate entity is your deep pocket, so you want to make sure you hold that corporate entity liable. Well, you can't name the corporate defendant as the defendant person and then turn around and allege that the corporation is operating and managing an enterprise that consists of the CEO, the vice president of marketing, the vice president of finance, the COO, the CIO. You can't do that because fundamentally a corporate legal entity is incapable of operating and managing itself. It's a corporate fiction. Corporations are only operated and managed by its officers and directors and employees and agents. And so you violate the distinction between the corporation person and the enterprise when you allege a corporation operating and managing a group of people, an enterprise that consists only of its own officers, employees, directors, and agents. The person-enterprise distinction is always important to remember. The second issue that people often run into troubles with when they're alleging an enterprise is that the enterprise has to be distinct from the pattern of racketeering activity. Now, this isn't a problem when you're alleging individuals as enterprises or when you're alleging corporate entities as enterprises. Those natural or legal entities are always distinct from the pattern of racketeering activity, which is why I like to allege those as enterprises, because it avoids this whole need to distinguish between the pattern of racketeering activity and the enterprise. Association in fact enterprises are really the only enterprises that have a problem with this rule. And essentially what the rule means is that a group of people has to be connected by more than simply the fact that they engage in acts of racketeering activity together. For many years it was debated as to how do you distinguish an enterprise, an association in fact enterprise, from the pattern of racketeering activity. And the first time the court addressed this issue was in the Turquette case. Turquette is found at 452 U.S. 576, 1981. And in that case, the Supreme Court basically said the enterprise always needs to be distinct from the pattern of racketeering activity. You can't point simply to the fact that people engage in criminal activity to call them an enterprise. There has to be something more. Well, for years, courts debated, well, what is that more? And you're going to see a lot of judicial opinions that discuss some need for structural hierarchy or an ongoing organization. All of that was very, very much inconsistent from circuit to circuit. That split wasn't resolved until Boyle versus the United States, a 2009 Supreme Court case found at 556 U.S. 938. And in Boyle, the Supreme Court said that an enterprise is distinct from the pattern of racketeering activity if three factors are met. Number one, the members of the enterprise need to share a common purpose, and that common purpose can be to defraud their victim or to make money or to engage in whatever acts of racketeering activity they're engaged in. So the first thing you need to prove is that the enterprise has a common purpose. The members of the enterprise have a common purpose. The second thing you need to allege and prove is that the members of the enterprise are related. Now this is a very factual question, and the degree of relationship doesn't need to be that strong. Obviously, if all members of the group are employed by the same company, that could be a sufficient relationship. If all members of the group belong to the same family, that could be a sufficient relationship. If all members of the group belong to the same community, that could be a sufficient relationship. A husband and wife alleged as an association in fact enterprise are related by the fact that they're husband and wife. You need to argue and allege that there is something beyond the acts of racketeering activity that relate these individuals to each other. It's not a high hurdle, but you need to identify some type of relationship. And again, what I was just saying about common purpose and relationship, the bigger your enterprise is, the more difficult you have establishing those two requirements. If you've got 200 people, how do you establish that all 200 people shared a common purpose? It's much easier to prove that 2 people share a common purpose. How do you prove that 200 people are all related in the same way? It's much easier to show that 2 people are related to each other. And so the larger your enterprise is, the more difficulty you have establishing the common purpose element and the relatedness element of the Boyle standard. Now, the third and final element of the Boyle standard is longevity. And longevity means that the group has to be together long enough to carry out its purposes. Now, longevity for purposes of an association in fact enterprise should not be confused with continuity. Continuity is an issue that comes up under the pattern element. An enterprise has sufficient longevity if after a day or an hour it acquired the money or property that it sought to acquire. When we get to racketeering activity, there are very definite rules about the continuity of the acts of racketeering, how long the acts of racketeering activity went on, and those are critical to determining whether a pattern has been alleged and established. Those are the main issues when you come to enterprise. Make sure that all of your enterprises are distinct from the defendant person. And also, if you're alleging an association in fact enterprise, make sure that that enterprise meets the 3 Boyle conditions, and that you've alleged those 3 Boyle factors, and that you have established that the enterprise is distinct from the pattern of racketeering activity. Throughout the day, we've been talking about the 3rd element, which is the defendant person must operate and manage the enterprise. And like I said, this is the whole point of Rico, is to get at individuals who don't get their hands bloody, who operate and manage other people or other groups or other legal entities from afar. Operation and management is a very fact-based standard, and the key case that you'll need to read when you're trying to understand the operation and management standard is the Supreme Court case of Reeves versus Ernst & Young. Now, Reeves is a very confusing decision. It sometimes seems conflicting and contradictory, like many Supreme Court decisions. But there is logic to the madness, more or less. In Reeves, the Supreme Court interpreted the phrase to conduct or to participate in the conduct of an enterprise through a pattern of racketeering activity. The Supreme Court interpreted that language to mean that the defendant must operate and or manage the enterprise. Essentially, if you have any discretion at all in carrying out your functions for the enterprise, you're an operator and manager. There are a couple of exceptions to the operation and management rule, but given that it is so fact-based, it's usually an issue of fact for the jury. It's very hard to get summary judgment on the basis that a defendant did not operate and manage an enterprise. For example, if you're a corporate CEO, or you're a vice president, or you're a partner in a legal entity, it's very, very hard to argue that you're not an operator or manager, because you're an owner, and your very title suggests that you're an operator or manager of the enterprise. Where it gets more murky is when you're talking about lower level employees, like secretaries or support staff, or people that don't necessarily exercise any discretion. In United States versus Viola, which is a Second Circuit case from 1994, the site is 35 F. 3rd 37, cert denied, in 1995. In Viola, the Second Circuit says that a gentleman named Formicino, he was a guy that performed odd jobs for a criminal enterprise. Mostly, he was a janitor. He did light cleanup work and maintenance work. But he was named as an operator or manager of the enterprise. When the U.S. government brought criminal charges, they cast a broad net, and they essentially name everybody employed by this criminal enterprise as a defendant. The Second Circuit said, yes, Reeves says that operation and management liability extends to not just people at the top of the ladder, not on the highest rung on the ladder, but also to operators and managers who are on the lower rungs of the ladder. But with regard to Formicino, the Second Circuit said that as a janitor, Formicino was not on the ladder at all, but as Viola's janitor and handyman, he was sweeping up the floor underneath of it. And so to avoid liability on the basis that you're employed by an enterprise, but you have no discretionary authority, you have to demonstrate that type of lack of discretion in your job functions. The other time that operation and management can be used as a trump card in a motion to dismiss or a motion for summary judgment is when you represent a defendant who is a professional, like an accounting firm or a law firm. As lawyers, we all know there are situations when you rely on information that's provided to you by a client, and sometimes that information does not turn out to be accurate. Despite your due diligence and everything you can do to determine the accuracy of the information, especially when your client is the only source, when it's a he said, she said situation and you have to rely on your client's version of events, you may not know that you are alleging information that is untrue or what have you, or you may not know that you're making statements in a letter that are false. And so a lot of times you'll see that law firms and accounting firms, accountants, for example, who get numbers that are cooked by their clients, are named as defendants. And the operation and management standard provides a way for those people to get out. In fact, Reeves was a case that involved an accounting firm. And the court essentially said in Reeves that, look, as long as you're without knowledge, you're unwittingly being used as a tool by the defendant to circulate false information or to circulate false numbers, financial figures, what have you. And as long as you're operating pursuant to your normal professional standards, you can't be held an operator or manager. But that rule also has exceptions, and one of the cases that I frequently refer to is the case of Handeen versus Lamar, which is an Eighth Circuit case found at 112 F. 3rd, 1339, 8th Circuit, 1997. In the Handeen case, the plaintiff essentially alleged that a law firm had orchestrated a fraudulent bankruptcy proceeding as a means to avoid paying the plaintiff's judgment, a judgment that the plaintiff received against the defendant debtor in a prior civil action. But that rule also has exceptions, and one of the cases that I frequently refer to is the case of Handeen versus Lamar, which is an Eighth Circuit case found at 112 F. 3rd, 1339, 8th Circuit, 1997. In the Handeen case, the plaintiff essentially alleged that a law firm had orchestrated a fraudulent bankruptcy proceeding as a means to avoid paying the plaintiff's judgment, a judgment that the plaintiff received against the defendant debtor in a prior civil action. The bankruptcy fraud was very elaborate. It was beyond the fraud that a debtor could have probably orchestrated himself. And so the plaintiff sued the law firm, claiming that, look, this debtor didn't come up with all of these means to evade the bankruptcy process or to hide assets from the bankruptcy process. The debtor had to have help. The debtor had to have someone who came up with this plan, who came up with all of the ways of concealing assets, and the help was the law firm, the debtor's bankruptcy counsel. And the Eighth Circuit said, you know, if these allegations are proven to be true, absolutely, these lawyers can be held liable. The Eighth Circuit said an attorney's license is not an invitation to engage in racketeering, and behavior prohibited by 1962C will violate Rico regardless of the person to whom it may be attributed. And we will not shrink from finding an attorney liable when he crosses the line between traditional rendition of legal services and active participation in directing the enterprise. The pole star is the activity in question, not the defendant's status. And so as a lawyer and accountant, you have to be careful. I mean, if you knowingly cross the line and you stop being a lawyer but start being a co-conspirator, you start being an operator or manager of the enterprise, then RICO may be a claim that you face. And courts, like the Eighth Circuit said, shouldn't shrink from imposing liability on people just because they're lawyers. Those are the two main rules when it comes to operating and managing an enterprise. People who are so far removed from any discretionary functions may not be operators and managers, but that is a very, very, very difficult task to prove that you're not exercising any discretion in the enterprise's affairs. And then professionals who are unknowingly used as tools by the defendant person to circulate false statements or false financial figures, and who are operating pursuant to their normal rules of professional conduct, generally are not considered operators and managers. That being said, however, that law firm or that accounting firm could certainly be an enterprise, and many times, those professionals are great enterprises if you're going after a deep pocket corporation and you're trying to find an enterprise that is distinct from the corporation. Law firms, PR firms, accounting firms, they're often a very good enterprise to utilize. That covers the first three elements of a RICO claim. A defendant person must operate and manage an enterprise. And then the last two elements are through a pattern of racketeering activity. So let's first discuss acts of racketeering. And oftentimes you'll hear acts of racketeering referred to as predicate acts. And all that it means is that essentially RICO liability has to be predicated on certain specified criminal activities. You cannot negligently violate RICO. You can't unintentionally violate RICO. RICO liability is based on on criminal liability. If you look at RICO as a macro crime, in order to reach liability for that macro crime, you need to prove that the defendant operated and managed an enterprise that was engaged in smaller crimes, micro crimes. And not just any criminal activity, but criminal activity that is specifically listed in 1961-1. Now, there's over 50 acts of racketeering that are listed in 1961-1. So I could spend an entire semester. You could take a criminal law class and still not be educated on all of the different acts of racketeering that are listed under 1961-1. So I've got to boil it down here. I've got to summarize and focus on the ones that are most important in terms of civil RICO litigation. But essentially, 1961-1 is divided up into two categories. It's divided up into state crimes and federal crimes. When it comes to state criminal activity, you're looking at serious felonies. Serious felony charges, serious acts of criminal activity under state law will qualify as acts of racketeering under the federal RICO statute. In particular, murder, kidnapping, gambling, arson, robbery, bribery, extortion, dealing in obscene matter, or dealing in a controlled substance or listed chemical. All of those crimes can constitute acts of racketeering so long as they're punishable by imprisonment for more than 1 year. So when you're looking at different types of racketeering activity that may serve as a basis for your RICO claim, those state crimes are available. But as I said, they're very, very serious state crimes, and in the world of civil liability, fairly unusual. You don't get a lot of kidnappings that result in civil RICO claims. You don't get a lot of arsons or robbery that results in civil RICO claims, or murders. You will find some robbery, some bribery, some extortion. Those are more common, but still fairly unusual in terms of civil RICO liability. Now, the bulk of acts of racketeering activity are found under federal law. And as I said, there's over 50 acts of racketeering listed in 1961 1B. And when you look at I don't want to call them the most important acts, but I will call them the most common acts of racketeering. By far, the most common acts of racketeering are mail and wire fraud. Mail fraud is found in 18 U.S.C. section 1341. Wire fraud is found in section 1343. Essentially, to prove or allege wire fraud, you need to allege and prove a scheme to defraud that is furthered or facilitated by use of the mails or wires. When you look at the mail and wire fraud statutes themselves, they are much broader than common law fraud. And that's where most people, including a lot of judges, get a bit confused. The very definition of mail and wire fraud under 1341 and 1343 states that the scheme to defraud may be by means of false or fraudulent pretenses, representations, or promises. And if you know anything about common law fraud, you know that generally common law fraud can't be based on promises unless there was never an intention to perform the promise, which is difficult to prove. So mail and wire fraud violations can be based on false promises. When you look at a lot of the case law in the different circuits, you will see many of the circuits state that mail and wire fraud can be based on such broad activities, just failing to abide by standards of fair play, failing to abide by standards of moral uprightness. It's a very broad statute. And this is why RICO has been abused so much, because civil attorneys will look at the breadth of the mail and wire fraud statutes and they'll say, I can make anything into a mail and wire fraud violation, and if I can make anything into a mail and wire fraud violation, I can make anything into a RICO claim. And so for the first 20 years of RICO's existence, you saw RICO being applied in all sorts of situations where judges did not want it to be applied, where Congress probably did not feel as though RICO should be applied. For example, You might have a product defect case which says this product performs a certain function without flaw, or this product operates at certain efficiency levels, and then people pay more for the product because they want that function, or they pay more for that product because they want that efficiency and they think they're going to save money. And then as time goes on, people start doing their own research on the product and discover that the product doesn't have that function or doesn't operate that efficiently. And so people start asking, why did we pay more for this product rather than just buy your standard product at a lower price? And then, so rather than bringing a breach of warranty or product defect claim, lawyers would argue, well, you know, they made a false statement in their advertising. They said it performed at this level of efficiency. They said it had this function when it didn't. That's fraud. The ads were circulated by mail and wire. That's mail wire fraud. That's Rico claim. Let's get up. Let's go. And judges say, wait a second. This is all handled. We've been handling these cases for many years, many decades, you know, without the need for Rico litigation. Why the heck are you guys and gals bringing these claims into Rico? And so they figured out ways to get rid of those claims. And proximate cause and statute of limitations are two of the big ways. But in any event, I encourage people to not bring Rico claims. I encourage people to not manufacture Rico claims. Judges see through it. Federal judges are not. They're federal judges because they're pretty smart people. And when they see a manufactured Rico claim, when they see a breach of contract claim that's bootstrapped into a mail wire fraud violation that's then bootstrapped into a Rico claim, they're probably not going to look kindly on your Rico claim. When they see a product liability case that's bootstrapped into a mail wire fraud case and then somehow evolves into a Rico claim, they're not going to look very kindly upon it. And I get lawyers after lawyers after lawyers saying, oh, well, you know, it's mail wire fraud. Mail wire fraud is so broad, and people act like they're the first, they're you know, the first people to discover the breadth of the mail wire fraud statute. Everybody knows they're broad. That's been the whole problem with Rico for decades. And judges are not going to accept claims. They're going to figure out a way to get rid of claims that they don't feel belong under Rico. And believe me, there are a million ways in which a judge can get rid of a Rico claim if the judge wants to. You can do everything right and a judge can still bounce you because many of Rico's rules are so subjective. And it doesn't matter if you want to get into federal court. Judges obviously are not going to let you stretch Rico too far simply so that you have federal question jurisdiction. Doesn't matter if you want treble damages. Doesn't matter if you want your attorney's fees. Judges are going to look at the underlying conduct and they're going to say, is this really criminal? Or is this, you know, common law fraud? Is this common law breach of fiduciary duty? Is this common law breach of contract? Is this common law product liability? This is, you know, I can't stress it enough. Don't abuse the mail and wire fraud statutes. Use it when it's warranted. Use it when you're dealing with conduct that is beyond what people would expect in normal commercial relationships, beyond what people would expect in their normal business relationships. Certainly don't use it in a situation where you'd have difficulty establishing common law fraud. If you don't have common law fraud, I would be very hesitant to bring a mail or wire fraud claim, with the exception of reliance. And again, we'll talk about that more in the second video. Reliance, or the lack of reliance, isn't necessarily a death knell for a Rico claim predicated on mail and wire fraud. But in any event, mail and wire fraud is a very common claim to allege, and there's plenty of fraud that goes beyond normal expectations in commercial relationships. And so that's an avenue that's available. A lot of times people will say one common defense you get to mail or wire fraud claim is, well, the misrepresentations weren't mailed. They weren't transmitted by wire. That's not required. All that's required is a scheme to defraud, which means, you know, I'm essentially making a statement to you and then you're losing money because of that statement. It's not required that the false statement be actually mailed or wired or transmitted. The only thing that's required is that the mails or wires be used to further or facilitate the scheme to defraud. For example, lots of times especially in consumer fraud cases. You'll have these internet companies that go online and they promise, to mail you out a product if you pay $100 on your credit card, the product will be shipped within a day or two. And then of course people pay the $100 and then they don't get the product at all, or when they get the product it's not what's promised. And so they call up, the customer care center, and if they're lucky enough to get on the phone with somebody, the person on the phone will say, well, it's still coming, it's in the mail, just give it a few more days, and the customer will call many, many times, and eventually the customer realizes they're never going to get the product they ordered and they were just ripped off $100. Well, all of those telephone calls can be uses of the wires in furtherance of the scheme to defraud. For example, in cases where the product isn't what you expect it to be, it's of lesser quality, or it doesn't have the functions that you expect, and then you receive it and you recognize that it's a piece of junk. The person on the phone could truthfully say, yeah, it's being sent out in 2 days, it's being sent out in a week. That's not a false statement because the product was sent, and the sales rep, the customer service rep, didn't make any statements about the quality of the product. But that's still a use of the wires in furtherance of the scheme to defraud. Likewise, the credit card company, there's no fraud in the wire transmissions relating to the transfer of money, but because the wires were used to transfer money from your credit card company to the vendor's merchant account, that use of the wires is also an act of wire fraud in furtherance of the scheme to defraud. So just because you don't have false statements being mailed or wired doesn't mean you don't have mail and wire fraud. So there's a Supreme Court case that stands for the principle that fraudulent representations don't need to be mailed or wired. Any communication in furtherance of the scheme to defraud violates the mail and wire fraud statutes. The case is Schmuck versus United States, 49 U.S. 705 from 1989. I always encourage people, though, to look at some of the other acts of racketeering, and I think that if possible, you should always allege something more than mail and wire fraud. It's not always possible, but sometimes it is. Other acts of racketeering that I find commonly available are bank fraud, which is Section 1344. Essentially, it says it's a crime to obtain money or property under the control of a financial institution through fraud. There are cases out there that will say that only banks have standing under the bank fraud statute, but that's okay. Even if you're not a bank, you can still allege that bank fraud occurred, and it can be an act of racketeering that's part of the pattern, as long as you were injured by reason of an act of mail or wire fraud. So I will often allege bank fraud, or financial institution fraud, even though I know that I can't allege a causal relationship between the acts of bank fraud and the plaintiff's injury, unless my plaintiff is a bank. Another one that often is available to people is Section 1512, which is obstruction of justice, 18 U.S.C. Section 1512. That essentially criminalizes any effort to obstruct federal judicial proceedings. I've seen Rico defendants interfere with my ability to depose witnesses. I have seen Rico defendants interfere with my ability to obtain documents. I have seen Rico defendants hide documents. Other acts of racketeering activity, though, may occur, especially if you've got like a whistleblowing plaintiff who essentially says, I'm going to report you to law enforcement, and then they may call that plaintiff and threaten the plaintiff with losing their job, or they may threaten the plaintiff with some kind of retaliation. They may threaten to make posts on social media that defame the plaintiff in an effort to discourage their report to law enforcement. All of these things could constitute obstruction of justice. So that's one that is available. Probably the most helpful act of racketeering, other than mail and wire fraud, is interstate transportation of stolen property, which is a very broad statute, and essentially it says that if you obtain property or money by fraud, and that property or money has a value of greater than $5,000, and you transport that property in interstate or foreign commerce, you've committed a federal crime. I use that statute an awful lot in conjunction with mail and wire fraud, because obviously in all of these cases the defendant's whole point is to get money from someone. And so as long as you're dealing with transactions that, or an aggregate amount of transactions that exceeds $5,000, you've got an arguable violation of Section 2314. All of this is a very, very rough, a very summary analysis of RICO, and I encourage you to rely on the book and engage in your own research, but I'm just trying to point out some of the major issues that you may confront in bringing a claim under 1962C. So finally, we're going to talk about patterns of racketeering activity. And the number one way in which you know whether someone understands RICO is whether they rely on the statutory definition of pattern. The statutory definition of pattern talks about 2 or more acts of racketeering activity within 10 years of themselves. That's basically what the statutory definition says. After the Supreme Court's decision in H.J. Inc. versus Northwestern Bell, which was a 1989 decision, 492 U.S. 229, that statutory definition is essentially irrelevant. Nobody relies on it anymore. It has very little utility. The Supreme Court essentially rewrote the statutory definition of pattern in the H.J. Inc. decision. So when I get a RICO complaint and it relies on the statutory definition of pattern, I know that the person who wrote the RICO complaint doesn't know rule number 1 about RICO. So under H.J. Inc., what is the definition of a pattern? The definition of a pattern under H.J. Inc. is that a plaintiff must allege and prove 2 things. Number 1, that the acts of racketeering activity are related. And number 2, that the acts of racketeering activity are continuous. So what does relatedness mean? Relatedness means that the acts of racketeering share the same or similar purposes, results, participants, victims, or methods of commission, or are otherwise interrelated by distinguishing characteristics. And that's found in the H.J. Inc. decision at page 240. So when you're looking at the acts of racketeering, and again, you might remember when we were talking about Boyle, we talked about the members of the enterprise sharing a common purpose. Well, here, under H.J. Inc., you need to show that the acts of racketeering share a common purpose. And again, that purpose could be to defraud the plaintiff of money. The results could be that the plaintiff was defrauded of money. The participants, obviously, would be the defendant person or members of the defendant person's enterprise, or employees, agents, other independent contractors acting on behalf of a corporate entity that's operated and managed by the defendant. And you would want to allege and obviously establish the common purpose, the common results, the common participants, the common victims. Oftentimes you may only have one victim, but especially in cases of consumer fraud, multiple consumers injured by the same false representation, or you're going to see multiple victims. There are some cases, circuit courts out there, that look to multiple victims as being a positive factor when it comes to establishing the pattern. And so if you can point to more than one victim, that is sometimes a good thing. But just remember, under H.J. Inc., if there are other victims, it's important that they be same or similar to your plaintiff. Methods of commission can mean the acts of racketeering are all acts of mail or wire fraud. The method of commission is always through a false advertisement, or it's through false statements made during a telephone call to a customer service center, or what have you. So methods of commission, that's something else you need to allege and prove, and or otherwise interrelated by distinguishing characteristics. For example, you might have a defendant that engaged in the same acts of racketeering activity across multiple product lines or multiple industries. Those facts would be important to point out as well. The bottom line is that you need to try to allege and prove as many of these relatedness factors as you possibly can. But it's also important to remember that these relatedness requirements are stated in the disjunctive, meaning that obviously the more of these factors you prove, the stronger your claim is going to be. But, if all that you can establish is a common purpose, common participants, common results, that's fine. Then allege them. Allege as many as you can. But if you can establish multiple indicia of relatedness, then obviously do that as well. The more the better, but you don't need to establish each and every criteria that's mentioned by the Supreme Court in H.J. Inc. Basically, what it prevents you from doing is looking at the defendant's entire history of bad activity and alleging that everything that a defendant has ever done is part of a pattern. You can only allege the bad acts that are similar to the acts that injured your plaintiff. The other element of pattern is, like I said, continuity. And this is what the continuity criteria is substantially more complicated than the relatedness criteria. And the easiest way to prove continuity is through closed-ended continuity. Closed-ended continuity essentially is a temporal test. The Supreme Court in H.J. Inc. said that you can establish closed-ended continuity by proving a series of related acts of racketeering activity extending over a substantial period of time. So the question becomes, well, what's a substantial period of time? And pretty much every court that has considered that issue has tried to leave it ambiguous. Most courts will say that anything less than a year is problematic as a plaintiff. In between a year or 2 years, it's a gray area. Depending upon the circumstances, that may be sufficiently continuous. Once you get up to 2 years, that's generally good enough in most circuits. The more difficult analysis under continuity is open-ended continuity. And it's more difficult just because it's not, like I said, who knows what a substantial period of time means. We think it's basically over 2 years, but less than 2 years we don't know. Open-ended continuity could be based on one act. The Supreme Court says that essentially open-ended continuity can be pled on the basis of a threat of indefinite duration. That threat can be explicit or implicit. What's an example of an explicit threat? An explicit threat of indefinite duration would be, pay me $1,000 a month or I'm going to break your legs. What that means is that for the indefinite future, the victim is living under this threat that on the first month that the victim fails to pay $1,000, his legs are going to get broken. That might be, his legs might get broken tomorrow, or they might get broken 10 years from now. It's a threat, an explicit threat of indefinite duration. That one threat, under H.J. Inc., could constitute open-ended continuity. Now, of course, in the civil context, you seldom have an explicit threat of indefinite duration. Nobody walks up and says, I'm going to break your legs if you don't pay me $1,000 a month. So generally, you have to rely on an implicit threat. And the most common way in which parties rely on an implicit threat of indefinite duration is when the acts of racketeering activity have become the regular way in which the defendant does business. For example, if they're regularly defrauding consumers through false advertisements or false warranties, you will be able to allege that that's their regular way of doing business, especially if they've been sued multiple times in the past, and you can point to those prior lawsuits and say, yeah, they just regularly engage in fraud against their customers, or fraud against regulators, or fraud against business partners. That could be a threat of indefinite duration. The other thing that you have to remember about threats of indefinite duration is that a defendant doesn't get the benefit of fortuitous interruption. The fortuitous interruption doctrine essentially says that a defendant has to stop the acts of racketeering on their own. And so, and this happens a lot. A lot of times a plaintiff will bring a lawsuit, and it's only when the lawsuit is filed that the defendant stops engaging in their acts of racketeering activity. And the defendant comes back and says, hey, I only did this for a year. A year isn't sufficiently continuous. Well, as a plaintiff, you can come back and say, you only stopped defrauding me because I sued you. And there's a number of court cases that will support the plaintiff in that regard, and hold that that the defendant is not entitled to a presumption that the racketeering activity would have stopped but for the lawsuit being filed. Or, a lot of times defendants get criminally indicted and that stops, or they die. I've had defendants that died and it was only their death that stopped the acts of racketeering activity. So, If you've got a pattern that lasted for less than 2 years, but it stopped only because you sued them or they got criminally indicted, they died, or some other event occurred that stopped the pattern, but it had nothing to do with defendant, him or herself, making an affirmative decision to stop the acts of racketeering activity without some external pressure, then you can argue that it was fortuitously interrupted, and but for that fortuitous interruption, the threat would have continued indefinitely. One of the cases that I rely on a lot for this fortuitous interruption principle is All Waste Inc. versus Hecht, which is found at 65 F. 3rd, 1523. That is substantive liability under 1962C in a nutshell. And we will come back with the second video and discuss civil standing under 1964C. As I said, this is meant to be a summary. It's meant to be just a broad overview of the elements of a 1962C claim. I would encourage everyone to read the book more carefully if they're ever presented with a potential RICO claim, and obviously to not only read the book but to engage in their own research. RICO claims, substantive liability can vary greatly from district judge to district judge. It certainly varies greatly from circuit to circuit. You can never do too much research. This is only meant to be an overview, and you can feel free to call me as well. Most of my clients are other lawyers, and that's pretty much what I do day in and day out is help people plead RICO claims. We will be back in video number 2 with civil standing.